Urgent question, Mr John Mann.
Will the Leader of the House make a statement outlining in greater detail the possible changes suggested by the Prime Minister on television about the role of two committees in regulating complaints about fellow MPs?
The Leader of the House, Mr Andrew Lansley.
Thank you, Mr Speaker. Mr Speaker, the House will be aware that complaints concerning the conduct of honourable members, including that they have breached the Members' Code of Conduct, are subject to investigation by the Parliamentary Commissioner for Standards and then considered by the Standards Committee. Additionally, since May 2010, issues relating to Members of Parliament's pay and expenses from that date onwards, including consideration of complaints, are undertaken by the Independent Parliamentary Standards Authority. So two bodies are engaged with the issue of regulating the conduct of members. As of now and for the future, in relation to expenses, Ipsa is a wholly independent authority. Any issue would be considered by their compliance officer. The officer has powers to order repayment and to impose fines. Appeals may be made to a lower tier tribunal. Of course, Ipsa is not responsible for considering issues relating to the expenses system prior to the last general election, nor other matters of conduct. In January 2013, the Standards Committee was reconstituted following the decision of this House of the 12th of March 2012, reflected in Standing Order 149. This brought in 3 lay members. They participate in all the deliberations of the committee. The chair of the Standards Committee, by convention, seeks consensus amongst all the members of the committee. The lay members, additionally, have a specific right to submit an opinion on any report to the House and to have it published under Standing Order 149. It is the job of this House, where necessary, to enforce the decisions of the Standards Committee. The regulation of the conduct of members is the responsibility of this House. For a wholly external body to consider complaints relating to the conduct of members in this House, for example on participation in debates and the registration of financial interests, risks undermining parliamentary privilege. That is why the reports of the Parliamentary Commissioner and the role of lay members is incorporated within the work of a select committee of this House. We have a relatively new system in place for the regulation both of parliamentary expenses and for independent input to the Standards Committee. Both should give the public greater confidence in the system. We must, however, seek to make these regulatory processes more widely understood and more transparent. If we can strengthen the independent input, whilst respecting the exclusive cognisance of Parliament, we should do so. And as the Prime Minister said, whilst these are matters for the House and not for the Government alone, we are open and willing to consider approaches which would further strengthen our regulatory system.
Mr John Mann.
I suspect that the Leader of the House hasn't had the opportunity to spend time on the doorstep in recent days. If he had, he would find that there is virtual unanimity out there amongst the British people about the fact that members of Parliament should not sit in judgment on members of Parliament, that there should be no self-regulation by MPs of MPs. There are other issues that the public are angry about as well, but on this issue he has the power to initiate and do something. Why will he not come forward with proposals to immediately end self-regulation in this House, and in doing so as well, in the interests of transparency, will he ensure that the recordings of this committee are made public so that people can see on what basis the committee overturns the views of the Independent Commissioner for Standards?
The Leader of the House.
Thank you, Mr Speaker. I think the honourable gentleman underestimates me. In my conversations with members of the public, it is very clear that many members of the public are not aware, even now, are not aware that as from May 2010 onwards and for the future, the expenses of members of this House, including any complaints relating to expenses, would be considered wholly independently by Ipsa and would, if there were any found to have been overpayment or incorrect claims have the power both to require repayment and to levy fines. So that is wholly independent. I think it is also clear that, and we have to be, I think, aware of this, if we were to seek, for example, to make the Standards Committee or the Commissioner wholly independent, the position we would end up with is that the Commissioner for Standards, the Parliamentary Commissioner for Standards, would no longer have access to parliamentary privilege in relation to her investigations, which presently she does by virtue of her investigation being part of the proceedings of the Standards Committee of this House. Her role would be much more difficult to fulfil in the way that she does. So far as the relationship between the Commissioner and the Committee is concerned, I think in my experience the Committee are wholly transparent about the decision-making process that they have gone through and the arguments that they have examined and the decisions that they have reached. But that is a matter for the Committee, not for me.
Sir Gerald Howarth.
Mr Speaker, may I support my right honourable friend's view that there really should be some parliamentary input into these matters for the reasons that he so clearly set out. Is it not the case that this is not so much a failure of the system, but a complete and abject failure of the media properly to report these matters objectively, the result of which is that many of our constituents, as the honourable member has set out, have failed completely to understand exactly what has been the case in a recent report, and that it is time that the media should pay proper consideration to parliamentary reports rather than seeking to engage in witch hunts.
Well, Mr Speaker, I don't think I'm in the. I'm particularly seeking to ascribe blame anywhere. And in particular, if, as may be the case, there is a misunderstanding about the nature and effectiveness of the regulatory system relating to complaints against members, and that isn't well understood by our constituents, I think we should take it on our shoulders and do everything we possibly can to make it clear that we do have a robust system in place.
Angela Eagle.
Mr Speaker, over the last few days we've had a recalcitrant Cabinet Minister unwilling to show remorse for obstructing an inquiry by the Standards Commissioner, and we've had a growing public perception that a committee of MPs has let her get away with it. This has thrown doubt onto her conduct and onto the judgment of the Prime Minister, who seems unwilling to act. So, does the Leader of the House now agree with me that the system we have does not command public support and that we urgently need reform to restore public trust? Whilst we need time to develop a more radical reform, will the Leader of the House now consider, as a matter of urgency, removing the government majority on the Standards Committee and creating a more prominent role for the lay members? And will he also reflect in his answer on what he thinks should be the appropriate sanctions for a member who has breached the Parliamentary Code of Conduct with their attitude to an inquiry? Mr Speaker, in the foreword to his ministerial code, the Prime Minister writes, "Though the British people have been disappointed in their politicians, they still expect the highest levels of conduct. We must not let them down." Can the Leader of the House tell us if he's happy that the Prime Minister has kept his promise?
Leader.
Mr Speaker, I'm surprised that Shadow Leader thought this was an opportunity to express criticism of an individual member. I didn't understand it was proper to do so, but I am in your hands, Mr Speaker. As concerns the question of the decisions made by the Standards Committee, that is a matter for the Standards Committee. If I speak personally here, not on behalf of the government, but speaking entirely personally, I read very carefully the report that was published last Thursday, and having done so, I felt that I understood, and as it happened, speaking entirely personally, agreed with the way in which the Standards Committee had gone about this task. I'm very surprised that the Shadow Leader should seek to intrude a partisan element. The Standards Committee has never operated on a partisan basis, and I have no reason to believe that the party affiliation of the members of the Standards Committee had any direct bearing on their view of the cases that they consider. On the contrary, they consider it on the merits of the case, and they seek to reach a consensus. And frankly, the fact we have lay members, coming on to the point, if she'll listen to the answer rather than simply interrupt from a sedentary position. The Shadow Leader asked about the position of lay members. Frankly, regardless of the position taken by the members of this House who are members of the Standards Committee. If the lay members had expressed a dissenting view, frankly, that would have been more powerful than having votes. Remember, the Standards Committee didn't take any votes. The question of votes was really neither here nor there. The point is, the lay members have effectively what is a casting vote at the end. Do they agree or do they not? If the lay members did not agree with the members of this House on the Standards Committee in the report that was published and had published and in the future publish a dissenting opinion, I think that would be a very serious matter. And I think it suggests actually the power of the lay members on the Standards Committee is more, frankly, than if they simply had a vote. And I think we should reflect that we should understand that and reflect that in these discussions.
Order. Before we proceed further, I simply remind the House of what I stated in it yesterday, namely that Erskine May, page 396, makes clear that there cannot be debate on the conduct of an individual honourable or right honourable member other than on a substantive motion. There is not a substantive motion on the order paper today, and therefore I invite honourable and right honourable members to conduct themselves accordingly. Sir Nick Harvey.
Mr. Speaker, I serve on the Standards Committee and hadn't realised until the controversy of the last few days that the lay members didn't have a vote, and the reason for that is simply, as the Leader of the House has just said, it is not the practice of the committee to take votes. We talk about things at length, sometimes at inordinate length, to achieve a consensus, and the lay members participate very fully and very vocally. They bring to bear a great deal of experience gained in other walks of life, in regulating other professions, and they are listened to with great interest by the members of this House who serve on the committee. They have been a very useful addition, and as the Leader just said, they are given the opportunity, if they wish to issue a dissenting note at any point in time. They haven't chosen to do that either in the matter which has just been published or in any other matter. I think the system is actually working well. They have brought a great deal of extra expertise, and we should continue with this and see how it goes.
Leader of the House.
I'm grateful to my right honourable friend. I think he expresses it very straightforwardly and well. I would just say this. I think the House will know that if at any point the lay members of the Standards Committee were to present an opinion to the House which had the effect of dissenting from the decisions of the committee as a whole, I think the House would take that very seriously indeed.
Sir Kevin Barron.
The Committee of Standards adjudicates on individual cases, but also has a duty under Standing Order number 149 to consider any matters related to the conduct of members. Can I say, on the 22nd of March, before any of the current controversy arose, the committee received a thoughtful paper from lay members on their impressions of their first year on the committee from January 2013 to January 2014, which was also sent to you, Mr. Speaker, and was placed in the committee's programme for future discussion. The committee has already decided to examine the current system for consideration of complaints about members of Parliament to consider improvements as required. We will be drawing upon detailed terms of reference over the next few weeks, drawing on the lay members' reflections. The lay members will continue to play a leading role in this work. But I say the committee has reported the lay members' paper to the House, and it is available on our website. As the lay members say, it is a matter of regret that the Committee of Standards and Privileges recommendations on standards issues have not yet come before the House, but the committee is determined to lead on these issues in the interest of maintaining the integrity of this House. The committee does not think it's appropriate to keep a running commentary on its decisions in individual cases, but at our meeting today, the committee authorised me to say that it continues to believe that its individual adjudications are impartial, fair and non-partisan. It is extremely important that those who express opinions on these cases, both within the House, this House and outside it, should have read closely the careful reasons and evidence-based conclusions set out in each report. The committee will continue to work closely and cooperatively with the Commissioner to reach objective and fair and non-partisan adjudications.
The Leader of the House.
Well, Mr Speaker, if I may, I'm grateful to the Right Honourable Gentleman, the Chair of the Standards Committee. I think what he illustrates is, as I said at the conclusion of my response to the urgent question, it is a matter for this House, and the House does look to the Standards Committee, not least to advise the House on how our system of regulation of members' conduct can be as robust as possible. And I do hope that in consultation with the Standards Committee and amongst the parties, we can ensure that any views that comes forward, not least from the lay members themselves, are reflected in changes if necessary.
Sir Peter Bottomley.
May I pay personal tribute to Andrew MacDonald, who's just retiring as Chief Executive of Ipsa, and send him my best wishes. I resigned from the Standards Committee when the House authorities and at least one party trashed Elizabeth Filkin when Commissioner for Standards. I hope that we will recognise that in paragraph 156 of the recent report, the present Commissioner said that the committee might not agree with one of her conclusions, so that shouldn't be a big surprise to everyone when that actually happened. And the second thing is I hope that those who comment on our affairs and the way we run them will recognise that an honourable member has, in 2 days, raised questions about what fellow MPs have done, while saying that you shouldn't have a running commentary on what MPs are doing, which is an odd thing for that honourable member to do. And finally, that if we actually look at the paragraphs in a recent report, and I can just list very briefly which ones they are, 14, which was the accusation, 28, 29, 32, 39, 49, 56 and 61, will be worth reading by the media so that reports can actually show what the committee did, what the Member of Parliament did and what the Commissioner actually said. I think it would help all our discussions.
The Leader of the House.
Yes, I'm grateful to my right honourable friend, and he is quite right to draw attention to para 156, which I think, contrary to the impression one might have received, pointed to the way in which the Parliamentary Commission of Standards herself contemplated that the committee may not reach the same view as her on what she described as a finely balanced issue. But I do encourage members and indeed the press and others more widely to read the whole of the report. I think only by reading the whole of the report, the Commissioner's report, the appendices and the committee's report itself, does one gain a balanced view.
Mr Peter Hayne.
Mr Speaker, as a former Leader of the Commons myself, I yield to nobody in wanting to protect parliamentary privilege and the independence of this House from external interference. But the truth is the public think there is one rule for them and another one for us. And that's an intolerable position for us to find ourselves in, and we've got to do something about it. And there must be a solution which protects parliamentary privilege and the integrity, the continuing integrity of the Standards Committee's work, whilst having external regulation of this sort of complaint. Otherwise, frankly, we are not going to be in a credible position.
Leader of the House.
Well, the Right Honourable Gentleman will understand when I explain to him that while it is quite clear that, as we know from past court cases, that the expenses system in itself does not constitute parliamentary proceedings and parliamentary privilege does not extend to it, other aspects of the regulation of members' conduct quite clearly does. And the point I would make, which is, I think, an important one, a practical consideration, is that if the Parliamentary Commission of Standards were not reporting to the Standards Committee as a select committee of this House, but was entirely independent and established separate from this House, parliamentary privilege would not extend to her investigations. It would make it much more difficult to proceed with those investigations and to get them completed. They would be subject to legal challenge and procedural challenge. And actually what is clear is that the Parliamentary Commissioner can and does have the power to undertake all the investigations required.
Mr Jacob Rees-Mogg.
Thank you, Mr Speaker. It is enormously important that this House maintains its right to regulate itself because we do so on behalf of the British people, to whom we are democratically accountable, in a way no bureaucrat ever can be. It is therefore for the British people that we maintain our rights. Can we therefore do one of two things? Either have a proper and direct system of recall that will allow the electorate to determine, or to use our powers as set out, and Mr Speaker, you will approve, I'm going to quote from Erskine May, on page 855 of Erskine May, which would allow this whole House to come to a decision, to return the decision of the Standards Committee to that committee, and to make our own recommendations, which may be more robust.
I'm grateful to my honourable friend, and indeed he's quite right to point out, and indeed the shadow leader in the debate on the 12th of March 2012 agreed with the proposal to happily proceeded by consensus for the appointment of lay members, but she did so recognising that that it is a committee of this House and members who serve on it do so first and foremost, I quote her, because they successfully stood for election. They are ultimately accountable to their constituents for their actions, and indeed we are so accountable, and it is an important aspect of this House that we are accountable in that way, and that's where the fundamental authority here derives. But I would also, however, say my honourable friend raises the point about recall. I can't, of course, anticipate the Queen's speech and the future legislative programme, but the House will know that, as indicated in the coalition programme, we as a coalition government remain committed to the implementation of a system of recall, and we're looking to continue to look forward to bringing proposals in that respect.
Mr David Winnick.
No one's going to buy the idea that this has all got up by the media. We've got to recognise the mistakes which have occurred and be less complacent. And I've noticed on previous occasions when the House of Commons has been far too complacent before setting in reforms. Would the Leader of the House accept that not only must we have a system that satisfies ourselves regarding how we examine conduct, but satisfies the public? And at this moment of time, as my right honourable friend Fanifa said, the public are not satisfied. They do believe there are double standards, and we should take this on board as quickly as possible.
Well, I don't think I'm in any sense complacent about this, but I do think it is important for us to be clear, and indeed I hope as a consequence for the public to be clear, that for the future, and in relation to expenses cases that might arise at any point since May 2010, there is a wholly independent system. And that should be understood, because I fear, actually, the public debate is relating to the expenses system as it existed before 2010 and not taking into account the creation of an independent system as has been achieved since May 2010. Beyond that, actually, where the conduct of members is concerned, we do have to make a judgment, continue to make a judgment. It's one the Standards Committee has to do on a case-by-case basis, whether they are sure that their investigations are robust and whether they feel that the sanctions that they recommend are proportionate to the nature of the offence. That's something we in this House have a responsibility for collectively. But when it comes to, for example, the exercise of those sanctions, including suspension from this House, I find it very difficult to contemplate how suspension from the service of this House could be the responsibility of an external body. I think it should be the responsibility of this House.
Sir Andrew Stunnell.
The current episode is a product of the old expenses system and would not arise now, but nevertheless it has very much enhanced public concern, and there's no doubt that this House needs to respond. Will the Leader of the House agree that getting the recall bill into the Queen's speech and pushed forward rapidly is a very important component of getting that solution?
Well, my right honourable friend will understand I can't anticipate the content of the Queen's speech at this stage. I'd simply repeat what I said before. We are committed to the introduction of proposals for a recall bill.
Ben Bradshaw.
Most of us, Mr Speaker, thought we got rid of self-regulation after the expenses scandal and not before time. Given the doubts about the strength of the recall proposals, given the current saga, what can he say to reassure the public that the reform process, which must be a process without a full stop, has not stalled under this government?
Well, I think I would reassure the public in this way by saying, firstly, they have been very concerned about expenses. And albeit that there are clearly a small number of legacy cases which relate to the past, actually, now and for the future, we have a fully independent system which has the powers that it needs in order to take the steps where there is anything wrong. Although I think one can say since May 2010, echoing what my right honourable friend said about Andrew MacDonald as Chief Executive of Ipsa, I think they have come a very long way in objectively speaking, creating a situation that should command greater confidence about expenses. So far as the regulation of other conduct of members is concerned, I think the public have to look at individual cases and say, well, when these cases come forward, for example, relating to the registration of members' interests and where there are conflicts of interests or where members have behaved in ways that bring the House into disrepute, has the Independent Commission on Standards pursued it robustly? I think it's her job to do so, and I hope members and the public would say, yes, she does. Actually, these investigations are often, when you read the reports, very detailed and very thorough. And secondly, do we take proportionate decisions? That's a matter of judgment. But certainly I do think in recent cases, actually, when the Standards Committee have brought forward proposals, they have put robust sanctions in place where there has been that kind of poor behaviour.
Dr. Therese Coffey.
Thank you, Mr. Speaker. 2 years ago, the government introduced a Green Paper on Parliamentary Privilege, which was considered at length, which led to the introduction of lay members, including the lengthy discussion on whether voting rights should be granted or not. He's already explained the situation there, but would he also recognise that it was the Standards Committee that reopened an investigation into a former member, which led to that member eventually being charged and sent to jail, therefore showing that the Standards Committee will, without fear or favour, will continue to try and uphold the integrity of this House?
Yes, of course, my honourable friend is right about that latter point. Can I say, of course, the issue that we were discussing earlier relating to the question of whether there should be voting rights for lay members on a select committee was recently considered and reported upon by the Joint Committee on Parliamentary Privilege. And in their report, and we agreed with them, when they considered the Green Paper on Parliamentary Privilege, they did say that to do this may have unintended consequences, principally that by explicitly confirming that privilege extends to the Committee on Standards, which they would have required to do, it could be interpreted to mean that the same extension did not necessarily apply to other committees that include lay members. And they said this because there is a risk that including lay members with voting rights on select committees could be held in the courts to have removed from that committee its access to the exclusive cognizance and parliamentary privilege. That is a risk I don't think we need to run, frankly, because I think the lay members on the Standards Committee have the power they need, and I don't think they are any doubt about it. If they have any doubt about this, I think they should tell us and we should consider it and strengthen it. But if they believe they have the power effectively by offering a dissenting opinion to act as what is effectively a veto on decisions made by the Standards Committee, that is, I think, the power that they require.
Paul Flynn.
The great screaming nightmare of the expenses scandal has been churned up again, and the public will not leave the appendices. They have a very powerful impression of sleaze in this House, which is very damaging, and it will continue until we get rid of this very wasteful, cumbersome, bureaucratic system of expenses and replace it with a simplified system of allowances that would save 10 million a year, be popular with members, save a great deal of time, and virtually eliminate the chances of fraud. Isn't Ipsa an idea whose time has already gone?
Well, I think the honourable gentleman rather illustrates, I think, the nature of the misunderstanding. I think there is nothing in recent reported cases that implies directly a criticism of Ipsa, since they don't relate to expenses since May 2010. So, frankly, I think if there are issues relating to Ipsa, look at them in that context, but don't judge Ipsa by reference to cases that occurred before May 2010.
Sir Mingus Campbell.
Does my right honourable friend agree that it's necessary in considering an alternative system to take proper account of what parliamentary privilege amounts to? Essentially, it is to the effect that nothing said or done in this House can be relied upon in any court outside this House. A report by a commissioner to a committee is part of the proceedings of the House and is therefore covered by privilege. If, on the other hand, it is decided to establish an alternative form which involves a statute and the creation of a statutory body, that is a body which would be susceptible to any legal action and probably, and in many cases one can imagine, subject to judicial review, thereby bringing an issue of this kind not only into the public domain, but into the responsibility of the civil courts of this country.
Well, I'm not a lawyer, and I bow to my right honourable friend's knowledge in this respect. I think he's absolutely right about that. And I think, from my point of view, I think it is also a very practical question, which I will repeat. If we were in a position where the Commissioner constituted not as part of the role of the Select Committee and under the standing orders of this House, but separately, were trying to effect investigations in a similar way, but open to legal and procedural challenges in the way that my right honourable friend describes, I think actually the Commissioner's job would be made much harder.
Chris Bryant.
I've complained many times about the media and the way they've operated over the years in relation to Parliament. But I say to honourable members, I think there is no point in railing against the media on this particular issue. The truth is that the parliamentary system of self-regulation, semi-self-regulation has been on trial in the court of public opinion for a considerable period of time, and for most of our constituents it's been found wanting. So surely we need to take... I don't want us to suddenly change all the rules and chase popularity. That would be as foolish as staying put. But surely we have to keep under review not only the operation of this system in this House, but also in the other House, because it's about the whole of the political system, and frankly, there's as much dodginess down the other end of the corridor as there might be down this.
Well, I'm not sure I will pursue questions relating to the other House. That is for them rather than for us. But I think generally, the Honourable Gentleman makes a point. I don't think I was seeking to blame the media at all. I think I was saying quite openly, we take it on our own shoulders. In that sense, if we cannot communicate to our constituents effectively through the media and otherwise about what the facts are, then we should take it on our own shoulders that we've failed in that respect. But I do say, let's be frank and honest with ourselves. We are in a transitional phase. We are still in the transition between scrutiny of expenses as occurred and the mechanisms that occurred before May 2010, where there are continuing legacy cases, and the new system from May 2010 onwards. And the sooner, frankly, we can resolve any remaining legacy cases, of which I hope there are really very few, and move to a system that is based on the legislation brought into effect on May 2010, the better it is.
Mr Peter Bone.
Thank you, Speaker. I went doorstep canvassing on Thursday night, Friday night, Saturday morning, Saturday afternoon, and I was telephone canvassing last night. And there was one huge issue on the doorstep, and that was immigration from the European Union. What we're talking about did not come up once. Could I ask the Leader of the House just to give his personal opinion on whether recall would in fact help end the debate that we're talking about today? Because ultimately, if recall was in place, the British people would decide, could it be pure recall?
Well, as I say, these are issues that are debated by the public, and understandably so, and in my experience they do raise issues, and often actually want to have a conversation, not least when they have their Member of Parliament available, to understand, well, what is this all about and why is this happening? And because I think we do need to continue more effectively to explain the nature of the transition we're going through and the nature of the systems that should give the public greater confidence. So far as a recall bill is concerned, well, I fear the House will have to await the publication of the government's proposals on that.
Sheila Gilmore.
Thank you, Mr Speaker. When I was a member of a local council and when we were dealing with issues of standards, what we were always told was it isn't just what you think or how you perceive your actions or whatever, it's how they're going to be perceived by others. And in this situation where there's a danger, is there not, that all the good work, particularly on the expenses issue, which has been done since 2010, is now at risk of being undermined. Is the Leader of the House really not prepared to investigate and look at a different way of doing things?
Well, on the contrary, I think both in my first statement and indeed in response to what the Shadow Leader and the Chair of the Standards Committee said, I'm perfectly willing to look at proposals. I just think that we just have to be very clear about what the facts are and the situation that we are currently actually in. And when she says these things risk undermining the system, I think it's very important to reflect that the decisions that the Standards Committee have been required to make and publish recently relate to a legacy case from before May 2010. I don't think it should be interpreted as something which should be held to undermine the system of expenses, scrutiny, and regulation that has applied since May 2010. And to throw that, as it were, into the argument that things must change, I think would be misplaced. I think that should be judged in its own terms. But if there are other ways in which we can further improve the regulation of members' conduct more generally, of course, I'm willing to discuss it with members.
I entered this House on a platform for change, and no doubt I was assisted by my predecessors' outrageous expenses. Now, that was under a different system, I know, but knocking on doors in my constituency this weekend, people did raise the expenses issue with me, and they believe that nothing has changed. Can I ask the Leader of the House to take not only the mood of this place, but also the wider country, to make the necessary change we need?
Well, I understand what my honourable friend is saying, but I do think that he, and not least actually those members who came to this House in May 2010, all of us have a responsibility to explain to the public things have changed. And it is being independently regulated, and there is no sense in which, in relation to the expenses system over these last near 4 years and for the future, that members of this House themselves directly are engaged in the process of judging other members. It is independent. We don't have any say in it. The Ipsa do.
Mr Dennis Skinner.
Doesn't the Leader of the House and the Government realise that we're living in an austerity-riddled Britain where there have been more than 40% cuts in local government and more than 1 million people have lost the benefit in these last few years? That is the climate of the people outside. And governments of all kinds should realise that when it's set against that backcloth, you can't keep saying from that dispatch box, we're going to carry on regardless. Listen to the tune and the noise outside.
Well, I and members of this government are very clear about the nature of the austerity in public expenditure and across the country that is required, because we had a reduction in the income of this country of over 7%, equivalent to £3,000 per household. That's what happened under the last government. So, yes, everything has changed. But in this Parliament, in this respect, in relation to the expenses system for members of Parliament, it has changed. And it has changed so that it is more rigorous, it is controlled independently. Any complaints or failures in relation to that are investigated independently, and any enforcement is done independently. It isn't about members of this House or me being complacent about this, because for now and for the future, the system has changed.
Well, Blackman.
Thank you, Mr Speaker. Can my right honourable friend update the House on how many legacy cases remain before 2010? Because the reality is the system has changed. I was one of those elected to see fundamental change, but we want to see the House cleaned up and cleared up and know that these cases are at an end.
I wish I could say that they are. I can't say that they are. I mean, the answer may well be none, that there are such legacy cases remaining. And indeed, they may be raised. I don't know. There may be issues to be raised that haven't yet been raised. I hope they are relatively few. Following the Legg inquiry and others, it ought to be the case that they have been thoroughly looked at, and that the public should have confidence that issues that were brought out had been dealt with. I hope that is the case, but I can't say that there are none. I think that may be over-optimistic.
Mr Thomas Doherty.
Speaker, can the Leader of the House explain why the Prime Minister still believes in self-regulation of politicians when he's ended self-regulation of the press?
The Prime Minister believes in effective regulation, and, of course, the House itself. I mean, I hope I've explained to the House that there are issues relating to self-regulation. It will be very straightforward, and indeed, I remember in the debate on the 12th of March 2012, we thought, and I know my predecessor as leader and the shadow leader, actually argued by analogy that we were creating something that was more like the General Medical Council or the Bar Council in the involvement of lay members, in order to try and ensure that it wasn't self-regulation in the way that it had been in the past. But there are specific issues that we have to bear in mind relating to the relationship between that regulatory system and the exercise of parliamentary privilege, and in particular the question of how sanctions that were to be applied in this House can be applied by anybody other than this House itself.
Order. Standing Order number 24 application. Mr Nigel Adams.
Thank you, Mr Speaker. I seek leave to propose that the House should debate a specific and important matter that should have urgent consideration, namely UK Coal's proposed closure of Kellingley and Thoresby collieries. The House will be aware that following statements by UK Coal last week and the written statement made earlier today by my right honourable friend, the Minister of State for Business and Energy, that UK Coal is seeking investment from various parties to fund a managed rundown of its two remaining deep mines, namely Kellingley Colliery in my constituency and Thoresby Colliery in the constituency of my honourable friend, the member for Sherwood. Mr Speaker, what is being sought by UK Coal is taxpayers' money to effectively shut down two deep mines which have provided fuel to keep our lights on and jobs for thousands of people for several decades. In fact, today, Mr Speaker, I understand that around 40% of our country's electricity generation is still powered by coal. I think that given the perilous financial situation that UK Coal finds itself in, the House should be granted an urgent debate so the whole House can look at avenues that may be open for this industry. 1,300 jobs are on the line here, 700 of them at Kellingley Colliery in my constituency, and it's not just in my constituency and that of my honourable friend, the member for Sherwood, where the pain would be felt. It is also potentially be felt in the constituency of my honourable friend, the member for Worcester, who has a business in the materials handling industry that's dependent on Kellingley. My constituency has previously seen the closure of the Selby coalfield in 2004. The Selby super pit, as it was, captivated all who had the slightest connection with the coal industry. It began mining in 1983, but was closed in 2004. I should declare an interest here, Mr Speaker, as several members of my own family have been involved in coal mining. In fact, some of them worked at Kellingley Colliery itself during the 70s through to the 90s. Coal mining has been ongoing at Kellingley since 1965 and Thoresby since 1925. Mr Speaker, I've met with UK Coal, the National Union of Mine Workers, and most importantly, workers and family members who would be devastated should these mines close. I received an email yesterday, Mr Speaker, from my constituent Samantha Higgins from Selby, who wants me to ensure that their voices are heard and that everything is done to protect their livelihoods. Mrs Higgins' husband is a coal miner at Kellingley, as is her father-in-law and her brother-in-law. In fact, her brother-in-law was only taken on at Kellingley earlier this year. Between them, they've got 3 children under the age of 6 and 3 mortgages. The devastation that could befall this family should these pits close is not an isolated example. I can also quote, Mr Speaker, from a letter I received from the Bishop of Wakefield, who's not only concerned about the severe problems that would be faced by the workers and their families, but he's also rightly concerned about the long-term security of our energy needs as a nation.
Order. I note the observation of the honourable gentleman, member for Bolsover. I've listened carefully to what the honourable gentleman has said, and I have to give my decision without stating any reasons. I'm afraid that I do not consider that the matter which the honourable gentleman has raised is appropriate for discussion under Standing Order number 24, and I cannot, therefore, submit the application to the House.